a will can always be challenged in court. Everybody had signed thinking everything makes sense. But what the brother did not tell the court is that he moved all of the valuable property from the companies he had assigned to everybody else and put it in the company he assigned to himself.
So what can you enlighten us about having joint assets in the event of one person passing away?
When you are listing those people, list everybody who would legally be entitled to your estate, even people you're not taking care of.
What exactly is succession planning?
So in very simple dictionary terms, succession planning is
Welcome to Get Your Bag Right podcast, the home of financial wellness conversations in Africa, where we talk about money, wealth, life, and opportunities so that you can make informed financial decisions. At the end of it, we hope that as you're listening to these episodes, it can enable you to make informed financial decisions so that you can secure your bag. On today's conversation, we are going to talk about one of the things that is most overlooked by majority of us. We mostly focus on acquiring wealth. That means we are building our wealth. But one of the things we mostly overlook is protecting the wealth that we build. In life, two things are certain, that is taxes and death. But then what happens when we have amassed all this wealth and then we die? What happens to the redistribution of the wealth which we have acquired over the years? So today's conversation is being co-hosted by a lovely lady called Diana, who is a wealth protection lawyer, and she's going to be able to take us through the conversation of how to put our finances or how to put our assets in order so that by the time we are passing on, we have a clear understanding of how our assets are supposed to be distributed. So I'm going to let Diana introduce herself. I know I've just given a nutshell of what she does, but she's going to introduce herself wholly so that you can be able to understand what exactly does she do.
Thanks, Lynette. So my background is in both finance and law. I went ahead to acquire degrees in both finance and law. And when I started my career, I began working in tech, actually doing both business strategy, organization, and so forth, and legal work. And after that, I transitioned into law firms. So because of that, my background allows me to understand both the legal and financial aspects of planning for somebody's wealth, as well as planning for their businesses and so forth when it comes to succession. So that's who I am in a nutshell. And of course, additionally, I am generally a practicing advocate of the High Court. So I can do any legal work, but most of the time I do wealth protection.
Okay. So Diana is also our wealth protection lawyer. She has helped majority of our clients set up wills, do trusts, and also has guided them in that process of how to put their affairs in order when they want to also transition their assets to the next future generations in the event they pass on. So I'm going to start off this conversation by helping us understand what exactly is succession planning. I know there's someone who's listening in and they're hearing the word for the first time. So how can you help us understand what is succession planning?
Okay, so in very simple dictionary terms, succession planning is creating a way for things to move from you onto the next generation. Essentially, it's taking the things that you own, the things that you owe people, the things that you are owed, and putting them in a manner that is organized such that somebody else is able to take over from you when you're not there. A lot of us go around, earning money, building wealth, building assets, and so forth. But all that knowledge is inside your head. And if something happens to you, then all of it is gone because nobody knows where to start. So sometimes people can lose those things and so forth just because of that. So succession planning is making sure that does not happen.
Yeah, I think also people are evolving because I remember when I started my journey in investments back in 2014, People were rarely talking about succession planning. Ati writing a will. You want me to die? Everyone will be like, "Ai wewe, unataka tu nikufe ama umenipangiaje?" You know? So I feel like these days people are much more aware on the aspect of, yes, I'm acquiring wealth. Yes, I have these beneficiaries, or I have these people who are depending on me. So how can I put my affairs in order so that in the event that I pass on, I know that it's distributed to them on how I deem fit when I was alive. Yeah. So there's been a shift also in the investment field, or I can say in the wealth creation field, which is actually a good thing. Yeah. Okay. So help us understand what it means to die intestate. I know that is a term that people talk about. Yeah. What does it mean to die intestate? Yeah.
Well, so the first thing you need to know is, unfortunately, in Kenya, majority of people die intestate because most people don't make any kind of arrangements. We live like we're going to live forever.
Yeah.
And that's just
We're immortal.
Yeah, we live it like we're immortal. We think, oh no,
Yeah.
I'll deal with those things later.
Yeah.
And then later never comes. Yeah. So what it means to die intestate is this. In terms of the law on succession in Kenya, you can either have a will or you can have property that's just sort of floating around. If you have a will when you pass that applies to your property, that is considered to be passing testate. So the opposite of that is now when you don't have a will and you just have property floating around in your name, that is dying intestate. So intestate just basically means there's free property that is in your name, which is not assigned to anybody by a document that you have created.
So I'm just acquiring assets left, right, and center, and I don't have any written agreement of how I want these assets that I've acquired to be redistributed once I pass on.
Sure, yeah, but let's not call it an agreement. Sorry,
okay,
legal
okay.
terms. It's more like a sort of, let's say like a deed sort of. Yeah, because an agreement it's a different thing.
Okay,
But yeah,
okay,
let's call it
okay.
a deed.
Okay, fine. So then what are other succession planning tools people can use other than a will? I know will is what people are familiar with,
Yes.
but then what are other succession planning tools that people can use other than wills?
So, well, okay, depending on the nature of somebody's property and the things that they run to day and so forth, there can be very many different options. But the key options that everybody needs to know, the basics, there are three. There are three basics. So number one is obviously the will. Just write down what you want to happen to your property when you're not there. Number two is the trust. Now, a trust is a bit more complicated. A trust is something that you create, let's say a legal relationship, which you create by taking the things that you have, putting them inside a secure vault called the trust in the hands of trustees on behalf of your beneficiaries. Beneficiaries, of course, being the people that you want to benefit from that property. So when you create this secure vault, you create certain rules that apply to the vault. And that property inside the vault cannot leave the vault without applying the rules that you have created. So that's what a trust is. That is option two. Option three, the one that all adults should also know, is called a power of attorney. Yeah. Now, a power of attorney is not about when you pass away. A power of attorney is something that we recommend for incapacity, because sometimes it can be that you're there physically but not able to do things for yourself, or maybe mentally you're not able to handle anything. So for incapacity planning, we recommend power of attorney. A power of attorney is just a document that says, the ability that I have as a human being to transact, I'd like to give this ability to somebody else to transact on my behalf. And usually we recommend that, especially for people who have businesses, or even if you don't have a business, if you have key decisions that rely on you. For example, you're the patriarch or matriarch of a family,
And then now you're sick.
and then you're sick and you're in the hospital and nobody can do anything because you're the one in control of everything. See, a power of attorney would help something like that, for example. Yes, so those are the three key succession planning tools.
Okay, so it's a will, a trust, and a power of attorney. I didn't know about the power of attorney. I just know people do powers of attorney. Maybe if you want someone to handle some affairs of you.
specific affair,
Yeah,
right,
yeah. I didn't know it can be used for succession planning. That's something I've learned today, which is actually a good thing. So then out of all these three succession planning tools, which one can be challenged in court?
Okay, wow, that's I am very tempted to give the classic lawyer answer of it depends, but I will not. I will not. So just to be clear, let me describe it in a way that makes sense, but also is very clear. So a will can always be challenged in court because when you create a will, it has to go through the court in order for it to be allowed to happen the way that you said is written. For it to be made a court order, it has to go to the court. So the will is always open to challenge. We, of course, usually when we draft wills as lawyers, we try to do the best we can to make sure that it's secure, that it is, even if it is challenged, it will stand the test of time. But you don't know what could happen between now and then. And sometimes, even, let's say, for example, if I say, okay, let's do a will for you, and we sit down and we write this fantastic will, and then you don't tell me, oh, by the way, there's a child I abandoned
Yeah,
10 years ago.
people don't
You
like
know,
saying the truth. People
Yes.
they don't want to be
You see.
ashamed, or you start thinking about me in another way. So people will just hide some information.
Exactly. So
Yeah.
you see, even if I write the best will in the world, if you don't tell me I have a
Yeah.
secret child, there's nothing that can be done at that point
Yeah.
in time. So the will is always open to challenge. Okay, that is number one. Number two, on the trust. Once you create a trust, the manner in which you have assigned things inside the trust is not challengeable under succession law, because once you create a trust, those things are no longer considered part of your estate. So they are not open to challenge in the same way that a will would be. A trust doesn't need to go to court to become a court order for things to be done the way you said they want them to be done in the trust. So a trust completely removes the succession challenge. But I want to be clear that there are times, I'm sure you've seen court cases where people have taken trusts to court. So what they're usually challenging is the way in which the trust is managed. So the way we do trust is that we make sure that the manner in which they're being managed is completely secure and has backups. Like somebody, like, for example, an enforcer, someone who would be able to say if the trustees are doing things that we don't like, that enforcer can stop them, for example, and so forth. So a trust can be challenged on the basis of this is being mismanaged. Yeah. And then the power of attorney is well, unless there's something about the way it was created that is wrong, usually it's not really something that you can challenge if it was done legally. Yeah, because you see, if we sit down together, me and you, and we write a power of attorney, and we make sure all the formalities are done correctly.
Yeah.
There's no, like, someone can't go to court and say and prove that maybe you were drunk when you did it, or
I've
maybe
not
you
of
are
full
mentally
capacity.
full capacity, for example, or full age, or maybe there was fraud, maybe misrepresentation, maybe I lied to you about something. So otherwise, other than those kind of things, in the foundation of the power of attorney, you can't challenge my having a power of attorney,
Okay.
for example.
Okay.
Yeah.
Okay. So, having worked as a succession planning lawyer here in Kenya, what are some of the disputes you've encountered between families, or just between also the clients you have been able to set up maybe a will or a trust, or also those ones who have not set up a will and a trust? What are some of the disputes you have seen that are common that people can also be aware of? Yeah.
Yeah, so as I said earlier, most Kenyans die intestate, unfortunately. So the most obvious dispute is that people cannot agree on who should get what. So I have an interesting story. So I have a client who wants to challenge the way that their succession was done, because what happened was, of course, when the father passed away, he didn't have a will, and they were required to divide the estate. So when they were dividing the estate, the elder brother is the one who's in charge of doing the administration, and he created a schedule for all the properties, and then they assigned those properties according to the schedule. What the brother did not tell the court is, you see, the manner in which they assigned the properties, everybody had signed thinking everything makes sense. But what the brother did not tell the court is that he moved all of the valuable property from the companies he had assigned to everybody else and put it in the company he assigned to himself. So when they went after succession, they discovered he had done all these transactions somehow, so that the company he assigned himself from the property was now the one that held most of the wealth in question. And then everybody else's companies only had minor, small properties,
Yeah.
So that's one of the examples. Most people simply just cannot agree on how the money should be allocated, and even when they do, sometimes family members can do things that are a bit shady.
Yeah. Is it an issue of trust? Can you fully trust your family? Maybe the trust, it's the some families trust each other so that when something happens, they can disclose 100%, like these are the assets all of us own and redistribute. But then there's families which trust does not apply.
Okay, here's the thing. Yeah, it's wonderful to trust people, but I'm sure you've heard the phrase "trust but verify." Because it's whatever your opinion is of this person, the truth is you don't know what they're going to be like after someone has passed away. You don't know if it might not even be at the point of passing away. It could even be that the minute they see, I don't know, the 100 million, 50 million, 30 million, a billion, the minute they see that in their hands and they have control over it, you don't know who this person will be. That's just a fact. You could believe what you like about this person. You could trust them completely with your life, but you don't know who they are when somebody dies.
Yeah, yeah. I think when you say that statement, it just reminded me of something my dad usually says so many times. He's like, you don't know people until you pass away. Like they can be your friends right now,
Exactly.
helping you, like, yeah, I can
Yes.
help you. But the moment you
But the
pass
moment you
away,
pass
that's
away,
when now you know their true colors. So
yeah.
you also have to have um that thing at the back of your mind to not trust people fully. Yeah. Okay, okay. I think you've also enlightened me there. All right, let's continue with our conversation. There's this aspect of, and I was part of it, there's this aspect of if I own land or if I own a joint investment with someone, or if I have an investment account with, let's say, my sister or my friend, we have built this investment account. If I pass away, the 100% goes to them. So, what can you enlighten us about having joint assets in the event of one person passing away?
Okay, so legally speaking, there are two ways that you can hold property that's considered joint in the common terms. There are two ways to hold property. So there's holding property in common and holding property jointly, like legally jointly. Holding property in common means the property that exists, Lynette and Dana buy property together. Lynette owns 60% of the property, Dana owns 40% of the property. So if Dana dies today, the 40% still remains Diana's in the sense that it passes to Diana's heirs. So that one can be put in a will, it can go through the succession process and so forth and assigned to somebody else. Now, if you're talking about legally joint means this property, the land that was bought by Diana and Lynette, both of us own 100% of the property. So if Diana dies tomorrow, the entire property passes to Lynette. Lynette doesn't even need to, go through the succession process because joint properties have a right of survivorship. So she can actually just go to lands with her, with Diana's death certificate and say, can you, transfer this property? So joint properties, joint investments, joint accounts, and so forth, if they are legally joint, there is a right of survivorship for whoever is left behind.
Okay. But you see, most of us just do things jointly. I open an investment account, I'm like, yeah, let's build a portfolio. Oh, nakuja na your 5 million, mi nakuja na my 5 million.
Yeah.
Let's open a joint account. But then we don't think about the repercussions, as you had mentioned earlier, the repercussions of what happens if this other person passes on. I think we always have the notion of we are immortal. we will stay
We
here.
are going to be here. We'll have time to deal with this later.
Yes, we'll have time
There's
to deal
always a later in your head.
I know, and then you don't put our affairs in order, even
Yeah.
as we are now making those joint investments together, which is good. But I think also people need to know that there is some disadvantages, or you just need to sit down with a legal person to also enable you to make sure that you're doing things correctly. Yeah. Let's talk about the aspect of beneficiaries. Yeah. That is a much needed conversation where you'll find people, even as you are, because now I'm in the investment field, so I'm talking about now the investment field. In every investment account that you open, there's a part hapo chini that says, who is your beneficiary? Allocate 50%, 30%, 100%. So most people assume, yeah, I'm speaking for most people because I was one of them. I assumed in the event I pass away, my beneficiary will be given my investments without any fight. Like 100% goes to my sister because my sister, I've given her the 100% of my investments. So what role does a beneficiary play?
Okay, so the legal term for that sort of arrangement is called a nomination, and a nomination is considered to be a separate thing from your estate. When you have a nomination, that property is no longer free property. You can't assign it in a will. You can't take it anywhere else. It passes according to whatever you wrote down. But I just want to take a step back and talk about the basics of these forms. There are two types of forms that you can be given when you do investments, when you do SACCOs and so forth. There's a next of kin and there's a beneficiary nomination.
Next of kin,
Next of kin is completely different.
masimu kuambiwa kuna kitu imefanyika.
Exactly. So you see, if you don't update the beneficiary form, but you update the next of kin form thinking that it applies, it doesn't apply. So the next of kin is completely different from the beneficiary. Now, for the beneficiary forms, if there is a valid nomination, that property will pass according to the nomination that you created. That property will pass according to the nomination that you have created. So whoever you've put down as the person in the nomination, that's what they're going to get. So every time you have a major life transition, maybe you start working, you get married, you have a child, you get divorced, you have to remember to update your beneficiary forms every single time. Because one of the problems we have is people coming to us because they know maybe they had their spouse or whoever had a some SACCO shares or some investment in which there's a nomination, but the nomination is the person's ex-spouse or something like that, or maybe it's like their parent, their sibling, and so forth. So people need to remember to always update their beneficiaries. Yes.
Okay. I just want to help us understand, also help me understand, because I'm talking to myself, because a light bulb has come. You see, when you're opening, let's say, a simple money market fund account,
yes,
there's a part where it's written, allocate your beneficiaries. So people just put in, okay, me, I put my sister or anyone, yeah, then I'll put 100%. But the form is different. I've even now realized the form is different from the one for a SACCO. Because I believe the one for a SACCO is now the nomination form, because it doesn't come attached to the same application form.
Yes.
Yeah. So then the one for the SACCO, I believe, is the nomination form, and this other one is just a simple beneficiary. So then, if I have filled my sister as my beneficiary there, in the event of passing away, what role does this beneficiary, who's my sister, play?
Because the money market fund holders are different, I can't speak to a specific form because that will be giving general guidance on something that is not general.
Okay.
But what you need to confirm is this form a nomination form or is it a mere beneficiary form in which the beneficiary is just somebody who would benefit from your earnings, for example, someone who can collect from your earnings, or someone who can, for example, next of kin, someone who can be contacted in case something happens to you. So you need to check on the form itself. And if you're not sure from looking at the form, you need to confirm with them, is this a nomination form or is it just a general beneficiary form? Yeah, okay. So you need to confirm that on the with the specific provider for the money market fund.
Okay, fine. Thank you for that. So what are the key components of a comprehensive estate plan?
Well,
Maybe the must-haves.
yes, I think let's say the things that matter the most for a comprehensive estate plan. So number one is the full list of assets. Full list of assets. People
Unasema
always
zote,
neglect
si
all of
ati
them.
half.
Everything. The only thing that you don't need to list specifically is maybe household items. You can say household items in general.
So
For
people are
example,
petty.
yeah.
I want to give my spoon to someone.
If you want to give your spoon to someone, you list it separately. So to be clear, if
Yeah.
you have household items and
Yeah.
then within that household you have, let's say, jewelry that you want to give to a specific person, or your laptop needs to go to a specific person,
Yeah.
anything like that, you list household items and then you put those specific ones as part of the list individually. Yeah, so you need to write a full list of everything that you own. And we don't neglect anything. We don't neglect cars, we don't neglect mmfs, we don't neglect even tacos, pensions, even insurance. You write it down, anything that will be considered an asset. So that's first, assets. Second, liabilities. Okay, now you have all of these things, but who do you owe money to? Because sometimes someone can come after you're not there and claim, oh, this person owed me money, or they still hadn't finished paying for something or something of that nature. So you need to list liabilities. Assets, liabilities, how much of that liability is still left at any given time. And then now the people that need to benefit, the people who are important to you, who need to benefit from your estate if you're not there. When you are listing those people, list everybody who would legally be entitled to your estate, even people you're not taking care of. So in our example earlier, when we talked about secret children, for example, when you're listing the people who are supposed to be taken care of by your estate, you need to include secret children. Or you need to include, for example, if there are any children that you have taken into your family, those ones also need to be included. I think children you have taken responsibility for, you're acting as a parent to them, they also need to be included.
Okay.
And so forth. So those are the three key things: assets, liabilities, heirs. Let's call them heirs, not beneficiaries, because under an estate plan they would be considered heirs.
Okay.
Yes.
So then what happens if, yes, I have acquired wealth. I have acquired all this wealth. I have passed on, and then there's no one to claim my assets. What happens to my assets? I have millions of shillings in a bank account. Yeah. Then maybe I've just died. And maybe I was secretive. I was living a below life. But yet in reality, I have millions. So people just know, okay, fine, Lynette is not that wealthy. But then Lynette, in real sense, Lynette is wealthy. So then Lynette passes away. So what happens to maybe the small wealth that they know that I have? Maybe they will do the succession planning, it will be redistributed. But this big one, which they don't know about, it stays. So what happens to that one?
So, okay.
Is it given to our government?
Well, as a lawyer, I can tell you that when people come to us and say, I need to do succession, if you come to us, we say, okay, the first step is confirming. Do you know everything that they have? If you don't know everything that they have, sometimes it is necessary for us to hire investigators to find out, to find all the information. But if there's some things that maybe you won't find even with investigators. So for example, let's say you are purchasing property, let's say you had paid maybe a down payment, I don't know, somewhere in Upper Hill, but you didn't give that information anywhere. Maybe you didn't tell your family you were doing it because you're secretive, right?
Yeah, I was just starting the process.
Or you are just starting the process, so you hadn't gotten around to saying anything to anybody. You see, that information is not in any public registry because that property has not been transferred. It's not in any public registry. I would have to have known specifically the person you're purchasing that property from. If you pass away and that person just decides to keep quiet, there's nothing we can do, And that's why we always encourage succession planning at every stage of your life. So for something like that, for example, if that person just decides not to say anything, there's nothing we can do about it. There are other instances in which unclaimed properties go to unclaimed assets authority, for example. And if your family doesn't know to check there, then it's just gonna sit there for many years. And okay, I do have to tell you that sometimes there is corruption. So if your family doesn't know that some property exists, there are people who will take advantage of that situation. There are people who look out for succession issues because they know if something has happened and these people cannot find these properties, then they can just take them. I am not going to mention what sort of people look for this specifically because I don't want to be sued, but it's something that happens, which is another reason you need to do estate planning. Because if the properties that are going unclaimed, it's possible for somebody to just
Okay. Okay. So then at what stage should someone do estate planning? Let's say I've started working, or maybe I need to acquire assets so that I start estate planning. At what stage should an individual think of, okay, fine, this is the point where I have reached, now I need to start thinking about estate planning?
Okay, I think it's easier if I tell you at what point which milestones require succession planning in your life. So just to be clear, if you're an adult and you have anything over, let's say, 150,000 shillings to your name, you need to do an estate plan.
150?
At 150.
Okay.
150.
So
anything over, you need to do some kind of estate plan.
Yeah.
Because you can assume, oh, it's so little money.
Yeah.
But you know, for example, if let's say for example, you have 150,000 in your bank account.
Yeah.
And you die tomorrow, and then maybe maybe your parents didn't know you had that money in your bank account. You know, your spouse didn't know you had that money in your bank account. It's just going to sit in the account.
Yeah.
And then somebody is going to find something to do with that 150,000 eventually, because the accounts that lie dormant in banks or investments or whatever, accounts that lie dormant, someone is going to notice that they're dormant after some time. So if you have no use for it, someone will find a use for it.
Someone will find a use for it.
So if you're an adult from 18 onwards and you own anything over 150,000, you need to do an estate plan. If you get married, you need to do an estate plan. When you have a child, you need to do an estate plan. If you start a business, just start. It doesn't even have to be successful. The minute you start a business, you need to do an estate plan. If you get divorced, you need to do an estate plan. And all of these could be different depending on which of the situations you're talking about and who are the people that you would need to benefit from your estate at that point in time. So any of those situations, you need to do an estate plan. Yes.
Okay. Wow, it's every stage of your life.
Yes, exactly. The answer is now. The answer to your question is now.
You just said 150, so I'm like, everyone, majority of us need to start thinking about the aspect of estate planning. So as we end the conversation of today, and we're coming to a close of it, what documents should every adult have in place?
Yes. So the documents we talked about earlier, the 3 key tools of succession planning, every single adult should have all 3. Now, I understand that for some people, maybe they might not feel that they need a power of attorney, but you know, you could be in the hospital and nobody can make decisions for you because you didn't have any arrangements. You'd still need the power of attorney. So to be clear, all adults should have a will, a trust, and a power of attorney. Sometimes we can consider, depending on your circumstances, maybe you only need 1, maybe you only need 2, maybe maybe you can do some combination of them that protects everything. But ideally, if I was the one giving out this information, if I was the one making the decision, I would have all 3 because it ensures you're covered end to end.
Okay. Yes. And do they also need to have, let's say, a list of their assets? You know, some people they just know wako na mashamba. Unauliza, niko na moja hapo Syokimau, niko na ingine Kitengela. You ask them for the title deeds, they're like, hey, najua tu mali iko. So do they need to have documentation in place? Maybe as you had mentioned of these different stages in life, can they update their assets that they have acquired, maybe documentation also? Is that also necessary?
I mean, yes, but you know, if you have a will, a trust, and a power of attorney,
so
you would have all that information inside there. Yeah?
Okay.
If you're assuming you're not doing estate planning, you're assuming you're not doing estate planning, the bare minimum you should have is a full list of your assets, a full list of your liabilities, and a full list of your legal heirs. Yes.
Okay. What are legal heirs?
The reason I keep insisting on legal heirs is because sometimes people consider their heirs to only be the people they take care of, you know. Sometimes
my children.
Just the children that you take care of. But there could be somebody else that you are supposed to benefit that you haven't listed. For example, the secret children. always have to be added to the list.
I don't have secret children, my people. She's
Well,
just giving
yet.
an example.
For example, yeah. So, for example, secret children must be listed even if they're not part of your current family. For example, another example is when the ones I was saying where you take care of somebody, because you can create dependence by taking care of them.
What do you mean?
If you take care.
Now let's elaborate taking care. What do you mean taking care of someone?
So taking care is, legally speaking, is a qualitative term in the sense that it's about the different substances rather than a specific item. So if you take responsibility for someone in some way that
I pay their school fees
you pay their
because
school
they
fees,
can't afford
for
school
example,
fees.
or maybe you pay their rent and their food, their accommodation, you pay for maybe something that they need to live, their livelihoods and so forth, so any of these could create a dependence, and in so doing that person becomes somebody who's entitled to benefit from your estate.
Okay. Thank you for that clarification. So as we wind our conversation of today, what are the first 3 actions any listener can take into place just after they have listened to this episode?
Well, the first thing I would encourage people to do, if you have done nothing else, please sit down and write that list of assets. Even if you do nothing else from listening to this conversation, sit down, write that list of assets. You have no idea how often we end up having to do investigations because people don't know. So write the list of assets, photocopy all of your important documents, put them inside one folder. All your important documents, meaning properties, investments, and so forth, put them inside that one folder with your list of assets. If you do nothing else, at least do that. But then, of course, the next thing you need to do is speak to wealth protection lawyers like Diana and see, okay, what can I do about my estate?
Okay.
Yes.
Thank you so much, Diana, for coming onto this episode today. We've learned so much about wealth protection and especially what we need to do in the relation of as we are also acquiring wealth. Most of us acquire wealth, but we don't protect the wealth that we are acquiring. And that is what Diana has taken us through. And I believe we have learned 1 or 2 things in relation to protecting the wealth that we are building. If you feel like you need the services of Diana, I'm going to put her contacts and her email address on the screen and also put a pinned comment on the show notes of this episode so that you can always reach out to her and you can book a consultation with her so that she can help you put your assets in order. One thing is certain, and we're all gonna die. So even as you are acquiring that piece of land, or even as you're thinking about, I want to acquire my next home, always have the thought process behind your head in that, yes, I want to acquire these assets, but I also have to think about planning my estate, as Diana has said. In each stages of our lives, we need to start thinking about planning our estate. So until next time, my name is Lynette Chalo. Build wealth, protect wealth, and ultimately, I'm going to help you get your bag right.